in addition to wills and trusts, the wills and trust program that Goodman and Associates has also does a variety of other documents. One of them is a durable power of attorney. Now, a durable power of attorney is a document that is drafted under the purview of a state statute that allows you to appoint somebody as your attorney in fact. That attorney in fact is your agent, and that person is given the authority that you grant to them inside the durable power. Typically, the durable power addresses day-to-day living things, financial things, paying of mortgages, filing tax returns, taking care of your bills. Any number of things can be included in there. What's nice about a durable power is that in most instances it will avoid the necessity of you having to go get yourself appointed as a guardian for a spouse or another person who grants that power to you, or should have granted that power to you if they don't. And so you can avoid going to court and avoid the expense of that. Now, durable powers of attorney are, in terms of the law, a relatively new invention. Under old agency law, if your principal, the person granting that durable power or making you their attorney in fact, if that person became incapable of monitoring your affairs, that terminated the agency. And so your authority to act on their behalf was automatically cut off. About 30 some odd years ago, 35 years ago, the state passed a durable power statute, as most other states, if not all. And what that does is it changes that old common law. It says if you do and you grant the durable power of attorney, the power granted to you is durable. In other words, it will last past the point of your principal's incapacity, or physical incapacity, or legal incapacity. So that's the durability. It continues until you die or it's otherwise cut off under its own terms. So this is a very handy thing and people are quite concerned about, becoming ill and getting to the stage where they can no longer take care of themselves. So a durable power attorney, what we do typically is the spouses appoint each other as their attorney in fact and can act for them. And they won't need to go to court in most circumstances. And they're honored by the banks and insurance companies and other agencies that you might have to be dealing with, but for the fact that you're physically or legally incapacitated. Okay? Now, legal incapacity deals with your ability to have capacity, the state of mind to do something. So even though you don't have the state of mind to do something, if you've issued a durable power of attorney to somebody that you trust, they can act on your behalf. Okay? And that becomes very important in today's rather complex society. So what we do is the spouse is appointed as the attorney in fact in most instances, and we appoint one or two successors, typically a child or a nephew or a niece or an uncle or a brother is appointed as a successor. Sometimes people don't have large families to appoint people, so they'll appoint their mother or father. But you got to remember this, your mother and father is older than you, and they may have their own issues where they can't serve. And so you'll need a successor attorney in fact anyway. So that's what a durable power is all about, and we do those as well. Now, why do you need them? One, they're provided for by state statute, okay? If you become incapacitated, somebody can act for you. And it ensures that, someone you trust will be acting for you rather than somebody that might be appointed by a court who you don't necessarily want to be acting on your behalf. And then it'll also give you the peace of mind that if something does happen to you and you do become incapacitated, that your affairs are going to be handled. If you have the other financial aspects of your affairs in order, you're not going to lose your house. You're not going to be placed in a nursing home against your will necessarily, because financially things are going to be taken care of. But the nursing home situation is something else that causes a lot of concern. And so in addition to the durable power of attorney, we also do a healthcare power of attorney. Now, healthcare power of attorney is prepared under the purview of still another set of statutes. Now, the state of Michigan does not have a statute that supports living wills. Very frequently, we are asked, can we do a living will, or will we be doing a living will, and so forth. We don't do living wills at Goodman and Associates. And the reason is that they're not recognized by law. Most attorneys that do them saying, well, there was I think a 1998 case in which a judge mentioned that everybody should have a living will. Well, unfortunately, that judge didn't understand that the state of Michigan doesn't support living wills. What the state of Michigan does support, however, is a healthcare power of attorney. So, in a healthcare power of attorney, the person granting the power appoints what is known as a patient advocate. That person is your agent to make decisions for you, healthcare decisions, in a situation where you're not capable of it. Okay? People are still aware of the Terry Schiavo situation. This is a case in Florida where a young woman became comatose, and she did not have a healthcare power of attorney nor a living will. I think those were actually recognized in Florida, but she had neither. And so her husband assumed, based on doctor's advice, that his wife had been brain dead and that he wanted to disconnect her from the life support equipment. Her parents, on the other hand, said no. As far as they were concerned, her daughter was still alive and she shouldn't be disconnected from that equipment. Well, they had a 2.5, 3-year battle over that, into which the husband and the parents spent hundreds of thousands of dollars on legal fees, and it was finally resolved that the husband had the authority to terminate the extraordinary care and the machines that were keeping her breathing. As it turned out, she died very quickly, and she had been legally dead since the time of the accident that put her into her comatose situation. Now, I know that everybody hears about different situations where, somebody comes out of a coma, having been there for a long period of time. That really isn't going to apply to these situations. But based on doctor's advice and other advice, your healthcare agent can have the power to not have you hooked up to machines for years and years and not cause your relatives to incur hundreds of thousands of dollars of legal fees and medical fees as well, because the hospitals will not disconnect you unless they have directives. Your healthcare power of attorney gives you that ability. Now, when I was in law school, which was a long time ago, the professor always said, what if your clients walked out the door and got hit by a bus? Well, in my office, the ambulance would probably take you up to Beaumont. And at that point, you're in no condition, presumably unconscious or perhaps comatose or near death, you're in no position to sign a healthcare power of attorney. So what we do is we do one here that is a standby document that doesn't cancel any others that you can do when you go to a doctor's office, for instance. And most people are asked to sign one at a doctor's office these days, along with a bunch of other documents that you have to fill out when you get there. But your healthcare patient advocate will have a copy of the document that appoints them as the person who can make those decisions for you. Typically, they're not necessarily life or death, but even just the application of treatment is a very important decision. And if you've been hit by that proverbial bus, you're in no condition to do that. So that's why we do a healthcare power of attorney. There's another document that we do for you, and that's called a HIPAA release. Now, actually, most of us are probably pretty familiar with that. HIPAA is a federal statute that says that your providers of medical care cannot release your medical records to anybody without your permission. So typically when you go to a doctor's office, you're signing a HIPAA release to release your medical information to your insurance company and perhaps your spouse and perhaps others. Again, what we do is we do a general HIPAA release that is a standby document in the event you're not able to do it yourself, so that your family and your patient advocate and whoever else you want to have receive that information gets that information and can do with it as they see fit. So it's very important to have that either When you go into the hospital, if you're able to fill it out yourself, great, because they'll usually give you what we call the statutory form from the state of Michigan, which is fine. But if you're not in a position to do that, you always have one, so to speak, in your back pocket. So another thing that's done in these documents is that you name somebody as a guardian. Now, you don't have to have a will in the state of Michigan to name a guardian, but the naming a guardian is really just a nomination. Okay, now there you'd have to go to court to get somebody nominated or actually put into place as a guardian. But if you have a nomination, let's say in your durable power of attorney and your healthcare power, then you're going to be just fine because the court will have your nomination. Usually that's going to be honored by the courts, and so you don't have to worry about that. So we talked about generally most of the documents that the principal documents that we do. There's others too, and what we try to address is what we call funding. Now, as I said earlier, funding is the process of getting that stuff into the bucket that's created by that trust. Now, most people have a home. Now, I get people in here every day and they say, well, we don't own our home, Chase Bank does. Or, some other mortgage or mortgagee rather. So that's not true. In the state of Michigan, you have title to your property. You own your home. It's just liened or has a mortgage against it. But you're the title holder of it. And if you die, you don't want to have that property dealt with in such a fashion that you're forced to go to probate. So for instance, let's say your title to your house is husband and wife. So-and-so and his wife as husband and wife. That's a special status that's created in Michigan. Not every state has husband and wife or tenancy by the entireties. Most actually have joint tenancy with rights of survivorship, but not tenancy by the entireties. In any event, what if that's the title to your house, that's how it's held, and you and your wife are hit by that proverbial bus, and you're gone? What happens to the house? It's owned by your probate estate. If you don't have a will, it's that intestate estate we talked about earlier. If you do have a will, it's your testate estate, and it's got to go through probate in order for it to get to your heirs. And per the code, that estates and protected individuals code, the proceeds of it aren't necessarily going to go where you want. So sometimes people say, well, I have this house, the kids have lived in it, I have a son who's living with me or a daughter who's living with me now. I'd like her to be able to live in the house as long as they can pay the taxes and insurance on it, and then they can sell it and disperse the proceeds of the house to my beneficiaries, including the daughter or son that lives in the house or whoever's living in the house. You can do that. You can set it up inside a trust, but you got to arrange for that property to get to the trust. And so you do that, and what we use is a vehicle or a device called a ladybird deed. A ladybird deed is a warranty deed. It's not a quitclaim deed. Quitclaim deed says, okay, here are all my rights to my house. I'm giving them to that trustee. Happens to be you, but it's still in the name of a trust. That's not a good idea because you surrender control of that property. What a ladybird deed does is it says, I'm going to give the house to me, from me, to me as in a different capacity, a joint tenancy or rights or survivorship for life. It creates a life estate, but it also retains the power to sell, refinance, convey, give the property away, do what you want. If either of you or both of you own the property at the time of your death, it automatically goes to the trust. And so that is a major way of avoiding probate because it's automatically set up to go to your trust. You don't have to do anything other than that, record that deed and your property and the interest that you want to have protected inside the trust document that you do will be automatic, and it'll be everything will be taken care of. Another reason for using a ladybird deed is that the title companies don't necessarily want to deal with your trust. So sometimes the title companies will say, okay, you want to sell your house or you want to refinance your house, before we can issue a title policy or a mortgage policy for your purchaser or your new mortgage, you have to convey the property back out of the trust to yourselves, do the transaction, and convey it back. most title companies don't worry about that or don't require you to do anything if the property is held by you pursuant to a ladybird deed. So that's how we get real estate into the trust most often. There's other ways to do it outside of trust. You can set up joint tenancy, but what if your son or daughter that you give it to in joint tenancy predeceases you? Then what happens? And let's say they don't have any heirs. You're back to probate. So again, a trust and a ladybird deed in this particular example is the way to go. How about personal property? People have cars and furniture and collectibles, be they guns or Yadros or Hummels or whatever it happens to be. What we have you do is assign your personal property to the trust. It's a piece of paper, but it's recognized as effective by the courts. And so all your personal property is taken care of. What if you get property after you sign that assignment of personal property? Well, it includes after acquired property as well. So when you're buying something, in effect, you're assigning it to the trust almost automatically, and then you don't have to worry about creating a probate estate in that situation. Now, so let's talk about bank accounts for a minute. A lot of people have either accounts by themselves or they'll have it set up joint with their spouse or somebody else. What we have you do there is you have to go out and go to your bank and get the account changed over so it's payable on death or transferred on death to your trust. That way your trustee gets it and handles it the way you want it to be handled. The banks will typically require to give you that you give them either a certificate of trust or a trust affidavit. We prepare those as well as part of this package. And so there's a few other documents that we provide you with, including instructions on how to do this funding by yourself. And in most cases, again, you don't need to hire an attorney to do funding. It's not rocket science. And if we do get involved with funding, other than answering a question or two, we do charge for that because that's how we make our living. If you have to amend these documents and make major changes to them, we do charge for that. But in most instances, if you call Guterman Associates, either before you sign the documents or after you sign the documents, you just have simple questions, we answer them. We will not be sending you a bill. The Wills and Trust Now program is all-inclusive. It's intended to be a flat fee and to cover everything outside of funding and amendments to your documents that you might need at a later date. Now, do these documents last forever? No, and we can't assure you that they're going to cover all your circumstances going forward. Neither you nor I have a crystal ball that's going to explain all these things or address all these things in a document. So when you have a major change in finances, have a major change in your family, be it additional members, fewer members, health issues, or whatever, it's a good idea to call us and talk about whether or not your documents need to be amended. So we look forward to hearing from you, and we hope that you'll take us up on our offer of a no-obligation consultation. Again, if you come in, you can talk with us. If you decide not to retain us, there's no charge. Otherwise, we look forward to having all of you as clients.